Good morning, Council. This is the Monday session of the Kansas Court of Appeals here on January the 10th. Joining me as the panel is Judge David Bruns, who has been on our court since 2011, and also Judge Sarah Warner, who has been on our court since 2019. I have the honor today of presiding as being the presiding judge. I have been on this court since 2013. My primary role today will be timekeeper. I have this case has been set for 20 minutes. Doesn't mean that you have to take the full 20 minutes on either side, but you're welcome to do so. And we're not really necessarily strict timekeepers in that respect if there's a question being presented from one of the members of the panel. So with that, Council, I would ask that you enter your appearances here for us.
Good morning, Your Honors. Charles Lee for the plaintiff and appellant cross appellee in this case, Mid-Kansas Ag Co.
Good morning, Your Honors. This is Adam Burris appearing on behalf of the Pawnee County Co-op Association, the defendant and appellant in this matter.
All right, Mr. Lee, how are you wanting to split your time?
15 and 5, if I may, Your Honor.
Okay.
And Your Honor, just as a point of clarification, is it the court's wish that the appellee cross appellant would go first this morning?
Well, I assumed that the appellee would go first, or the appellant would go first. Why would you go first?
Your Honor, I'm the appellant for this appeal. Mr. Lee's client has filed a cross appeal.
Right, but no, I think the appellant counsel, or judges, I think the appellant goes first.
Yes.
The appellee responds, and then in that fashion. So I was going to ask if there's some difference in the way you wanted to argue the cross appeal and the response, but let's discuss that up front so we're all on the same page.
Okay, and I guess I had anticipated that I would go first this morning just because my client is the appellant, and then
go ahead.
And then Mr. Lee would follow up as the appellee, even though they have filed a cross appeal as well, and then I would follow up for rebuttal to that.
And Your Honor, that was my assumption as well.
All right. So, and then are each of you wanting 5 minutes to respond to the cross appeal and the joint appeal?
Your Honor, I had anticipated starting off with 15 minutes of argument and then reserving 5 minutes for after Mr. Lee's remarks to address it on rebuttal.
And then he would have 5 minutes to address his cross appeal.
That would be our preference, Your Honor. Yes.
All right. Just so I'm following. We don't get cross appeals very often, and so and procedurally, we just want to give everybody their chance in court to argue their case. So with that, Mr. Burris, you are the appellant. You may proceed with your 15 minutes.
Okay. Thank you, Your Honor. May it please the court. As I mentioned just a moment ago, I represent the Pawnee County Co-op Association, the defendant and now the appellant and cross appellee in this matter. The court is no doubt well aware of the facts of this case, and so I'm not going to spend a whole lot of time talking about the facts, but just as an introductory matter, this is a dispute over a commercial lease agreement that granted my client a leasehold interest in a grain storage facility located in Barton County, Kansas, and we refer to that facility as the Dundee facility. Mid-Kansas initiated this lawsuit by filing its petition in Pawnee County, seeking to terminate my client's leasehold interest and to terminate the lease agreement. and also to eject my client from the Dundee facility. As part of that suit, Mid-Kansas also sought monetary damages for breach of the commercial lease agreement and for fraud. We then filed a counterclaim based on the premature termination of our leasehold and the premature termination of the commercial lease agreement. We sought monetary damages for that. We went to trial in November of 2019, and after the jury considered the claims and counterclaims of the parties, the jury awarded Mid-Kansas a net verdict in excess of, or almost of $2 million. And following that, we timely filed our appeal that we're here this morning to discuss. Our appeal raises 4 issues that I want to talk about this morning. The first is that the district court erred in denying the co-op's motion to strike the testimony of one of Mid-Kansas's expert witnesses. Secondly, Mid-Kansas's fraud claim should have never gone to the jury because it was barred by the applicable statute of limitations. And because the third issue, because Mid-Kansas filed its petition in the wrong county, that the district court never had subject matter jurisdiction to hear this case in the first place. And then finally, the jury's verdict in this case, rejecting my client's affirmative defenses of waiver and estoppel, was contrary to the evidence that was presented at trial. So first, I want to start off by talking about this issue with the court erroneously admitting the expert testimony of Dr. Matthew Roberts. In its petition, Mid-Kansas alleged that the co-op violated a right of first refusal that was included in the lease agreement. And the theory of that claim is that when the co-op shipped grain from the Dundee facility, it was supposed to first offer it to Mid-Kansas for Mid-Kansas to purchase. And of course, Mid-Kansas claims that that was not followed. And so in support of Mid-Kansas's damage claim, it retained an expert witness named Dr. Matthew Roberts. And,
Mr. Burris, before you
Yes.
get too deeply in this argument, let's first talk about whether it's preserved for appeal. Was there an objection raised below?
The objection that was raised below was done pursuant to KSA 60-457, and that is dealing specifically with expert witness testimony. Before trial, we had filed a motion to strike the expert witness designation for Dr. Roberts. The basis for that objection, or that motion to strike, is that the methodology that Dr. Roberts employed really had no bearing or no application to the facts of this case. In Dr. Roberts' opinion, his damage estimate was based off of a whole series of facts that frankly just did not exist in this case.
Okay, let's stick on the procedure just a second. And that is, okay, so you filed a motion to strike prior to trial. Was that reiterated by an objection or some other way preserved at trial?
We have to acknowledge that there was not an objection raised at trial. In lieu of that objection, we went through this pretrial motion practice process. At that point, it was clear to us what the district court's ruling on the matter was.
How would this be any different than a order in limine, which you still need to object to trial in order to, or even the other side would need to present evidence to preserve it in the record? I mean, I'm trying to see why you didn't need to raise it at trial.
Right, and I guess our position is that by virtue of this procedure that is set forth in 60-456 and 457, that preserves the objection. And so in particular, where an instance exists like here, where the district court has made well known its ruling, that preserves the objection.
But do you think this is similar to a motion in limine or an order in limine, or is this a unique species in and of itself that an order in limine is interlocutory in nature? Yeah, the judge has told you how they're likely going to rule, but depending on how the evidence comes in, it could change. Are you distinguishing this from that type of order?
We think that it is distinguishable just because of the nature of this being expert testimony. And there's a separate procedure for the court to fulfill its gatekeeping function when it is dealing with expert witness testimony. And that is the procedure that we followed by filing our pretrial motion.
Okay, well, I understand that. What I'm having trouble with understanding, and I don't know that I know the answer. I need guidance from both of you. Is do you still need to raise this at trial? But you've made your position clear, and I don't want to take up all your time, so you can move on to the substance on that.
Okay, thank you. The basis for our motion to strike, as I mentioned, was that the facts upon which Dr. Roberts relied on really had no basis in this lawsuit. He formulated his damage figure for the right of first refusal by engaging in a rather complex analysis involving the hedging of grain futures.
Counsel,
Yes.
in respect to that question, aren't you truly asking us to reweigh the evidence that was presented to the jury and how they determined it should be applied?
Not necessarily, Your Honor. What we are seeking is to have this court determine that the district court erred in not granting our motion to strike. And the basis for that is that the facts that formed the basis for Dr. Roberts' damage conclusion just didn't exist in this case. He formulated his opinion based on a whole series of facts that Mid-Kansas engaged in a line of business that it has never done. The basis for his opinion was that Mid-Kansas would buy grain from the Dundee facility, which it never did, that Mid-Kansas would then hold on to this grain and store it at the Dundee facility or some other facility, which Mid-Kansas never did. And then
so it sounds like your argument is not that this expert was not qualified as an expert in some way, but instead that his arguments were unpersuasive because they weren't moored to the facts. Is that accurate?
Well, our position is that he did not qualify as an expert witness because he really didn't apply his methodologies to the facts of the case. He essentially had come up with his own set of facts and then applied his methodology to those facts, completely ignoring the nature of Mid-Kansas's business and what Mid-Kansas actually did. Mid-Kansas never engaged in this grain trading business that Dr. Roberts used to formulate his opinion. And apart from that, as we raised in our motion to strike as well, Dr. Roberts applied the wrong measure of damages when he was analyzing the right of first refusal.
Did you make those arguments to the jury, counsel?
We did, and we cross-examined Dr. Roberts extensively on the lack of factual basis of his opinion at trial. But as I was going to say, apart from the fact problems with Dr. Roberts' opinion, he used the wrong measure of damages. The right of first refusal, Kansas law is quite clear. The way that you measure damages is a loss of bargain. And that's simply the difference between what Mid-Kansas could have purchased this grain from the co-op versus the price that Mid-Kansas would pay on the open market. And so that
was along those lines, was the jury instructed as the proper measure of damages?
I don't recall, Your Honor. I
mean, what difference does it make if a witness says something, if the judge properly instructs the jury on the measure of damages?
Well,
because that's the law they're supposed to follow.
Correct. And I guess this relates back to, again, our motion to strike and it being an independent basis for why the district court should have granted it because you have this expert witness who is applying the wrong measure. And so our position is that it should have, the district court should have prevented that from being introduced at trial at all. And so for those two reasons, the fact problems and then the measure of damages, we felt that the district court should have granted our motion to strike, and failure to do so was an abuse of discretion. The second issue that I want to get to this morning is this fraud claim that was raised by Mid-Kansas. In addition to its breach of contract claims, Mid-Kansas alleged that the co-op committed fraud stemming from a billing dispute that arose at the end of 2012 and at the beginning of 2013. And at the close of evidence, or I'm sorry, at the close of of Mid-Kansas's case in chief, the co-op moved for judgment as a matter of law on this claim on the grounds that it was time barred. Under KSA 60-513 A3, a cause of action for fraud has to be brought within 2 years of when the potential fraud is discovered or could have been discovered.
Didn't the district court make a determination that was a fact question for the jury?
Well, the district
when it became discoverable.
The district court, I believe, well, there were a couple of problems with what the district court decided. The district court incorrectly applied the statute of limitations from when the actual fraud could have been discovered, when the actual fraud was discovered, and the district court determined that occurred actually during litigation. And that was, contrary to Bill Roenbaugh, the Mid-Kansas owner, contrary to his testimony, because he testified that his testimony clearly established that Mid-Kansas had actual and constructive knowledge of the potential fraud claim as late as January 2013. And since the suit wasn't filed until July of 2018, Mid-Kansas brought its fraud claim 3.5 years too late.
Counsel, wasn't there also testimony? I thought I saw some that I'm sure you would disagree with the testimony, but wasn't there testimony that basically your client lulled them into non-action?
There was testimony about that. There was also testimony that once this issue arose, and this is testimony from Mid-Kansas's own witnesses, that when this issue arose, it immediately aroused the suspicions of Mid-Kansas. And Mid-Kansas's owner performed an independent investigation, I believe, with his assistant, and determined that this was not a valid claim being raised by the co-op, and for whatever reason decided to pay the claim anyway.
Counsel, it sounds like there is some conflicting testimony on this, and it sounds like certainly you would like to focus on the testimony that you're highlighting here, but the fact that there is conflicting testimony, doesn't that necessarily mean that this is something that should go to the jury?
Well, I mean, not necessarily, just because the testimony that we're talking about is the testimony of Mid-Kansas. And so to the extent that there's conflicting testimony, this is testimony being offered by the same witnesses. And so they're self-contradicting each other. And so I don't think that serves as a proper basis for this issue to automatically go to the jury. The evidence at trial was that this clearly arose at the end of 2012 and 2013. And so we feel that the district court could have made a judgment in our favor as a matter of law on this issue.
Wasn't the issue though how wet the corn was at the time it was delivered, and whether or not the Dundee facility suffered shrinkage, when in fact it wasn't discovered during the time until the process of the litigation that your client never had any records to show the moisture content of the grain before it was put in the Dundee facility.
And so
doesn't that go to the fact question of when the disputed issue became known to the parties?
And that is certainly the position that Mid-Kansas took but that contradicts the testimony of Mid-Kansas's owner, that he knew immediately or felt immediately that the co-op's demand for payment involving this shrink issue was not valid. And so in that instance, when he feels that the claim isn't valid, and it arouses his suspicions, that is when the cause of action for fraud accrues, is when a party has constructive notice of the fraud. And that occurred in December 2012, or at the latest, January of 2013. But as I mentioned, the district court denied our motion, disregarded the testimony of Mr. Rohenbaugh on that point. But with those facts at hand, again, we feel that the co-op's motion for judgment as a matter of law should have been granted, and that the district court's decision in that regard was clearly erroneous.
You have used up your 15 minutes, but I'll let you have a little extra time to conclude the last two arguments.
Okay, thank you, Your Honor. I can be brief with the last two arguments here. The two arguments, the two issues that we discussed this morning need only be taken up by this court as long as the court finds that the district court had subject matter jurisdiction in the first place. And if not, then this entire case, including this appeal and the cross appeal, can be disposed of by this court. And this is the third issue that we want to talk about this morning, and that's that Mid-Kansas simply filed its petition in the wrong county. And when this defect was brought to the attention of the district court by the co-op in its motion to transfer venue, it was erroneously denied by the district court.
Counsel, I have a question. Why did you file a motion to transfer venue if you think that this was a jurisdictional defect? Why wasn't this a motion to dismiss?
It seemed to us that the petition was filed in July of 2018, I believe. We filed our motion to transfer venue in October. And so the timing of our motion, it struck us as a motion to transfer venue was more appropriate time-wise than a motion to dismiss, since we were a couple months into the case by that point.
And weren't you correct at that time that this really is primarily an issue of venue and not subject matter jurisdiction?
Yeah, we believe so. That in this case, this is clearly a case involving an interest in real property. It's a case where Mid-Kansas is seeking to or sought to eject the co-op from the Dundee facility, and that fits squarely within KSA 60-601, which mandates that actions for ejectment or actions that involve interest in real property must be brought in a county in which the real property is located.
Is that a venue statute or a subject matter jurisdiction statute?
It's a venue statute.
And venue can be waived, can it not? Where subject matter jurisdiction, you can't waive or stipulate to.
That's my understanding, Your Honor. Although with this particular venue statute, it's a little more specific than just the general venue statute that appears under 60-601.
Right, but my issue is, I mean, I understand the statute and I understand what you're saying. Subject matter jurisdiction, of course, is the court just can't hear it at all. So Kansas district courts are courts of general jurisdiction, of course. And so we start from the premise that they can hear every claim, and unless the legislature or the Constitution has set aside certain claims that school financing, for example, capital death cases, and certain things that bypass courts. So subject matter jurisdiction, I've got sun coming in here, sorry about that. Subject matter jurisdiction would mean that the court couldn't hear any of these claims. But if it's truly venue, as you say, then it seems to me that they could at least hear all the other claims and not claims specifically relating to the real estate.
Well, I think that, and we made this argument in response to a few of the motion to bifurcate Mid-Kansas had filed is that the issues were so intertwined, the breach of contract issues versus the interest in real estate issues, that there was really no way to differentiate the two. And so the conclusion that we reached is that 60-601, of course, requires this type of action, an action involving real estate, to be filed in the county where the real estate is located. And so it's a venue statute, but in a way, it's also a subject matter jurisdiction statute. Frankly, just because the plain language of the statute seems to indicate that the only way that a court has subject matter jurisdiction to hear a dispute like this is if the real estate is actually located within the confines of its borders.
And that would be regardless of the claim that's asserted. Would be your position.
Our position is that if it involves an interest in real estate, and if a party is seeking ejectment, then yes, it has to be filed in the county.
Well, but I'm saying all the other claims. I mean, there are a lot of claims besides ejectment here.
Well, and again, our position is that the ejectment claim and the termination of lease agreement, termination of leasehold interest was so intertwined in this case with the breach of contract claims that there was really no way to separate the claims. And so in our opinion, all of these claims had to be brought in Barton County, not just some of them.
Counsel, just to clarify, was the ejectment issue ever actually litigated?
The ejectment issue, I don't believe, went to the jury, although we have identified a number of instances on the record in the pleadings throughout the course of this case where it obviously was an issue.
And at the time of trial, isn't it true that your client had indicated that it was going to be vacating the premises about a month after the trial anyway?
My client, our position was that the lease agreement provided a termination date of December 31st of 2020. A party could choose to terminate the lease early, provided they gave a 1-year notice. And so my client's position was they were going to give that notice December 31st of 2019. And so that happened to be a month after the trial took place.
But they gave the notice in December of 2018 that they were leaving in December of 2019. Isn't that correct?
That's correct. There were some timing. There's a timing mechanism in the lease agreement for when the notice actually has to be given.
So what I'm getting at, by the time of trial, all the parties knew that your client was no longer going to be in possession of the facility voluntarily.
That is true, and that is a function of receiving a demand letter from Mid-Kansas that it was no longer going to accept grain at the facility. And so my client really had no choice but to.
Well, and that led to your counterclaim.
That's correct. That's correct. And the basis for our counterclaim is the reduced volume of grain that we got from our customers by virtue of not being able to use this Dundee facility. Your Honors, I want to close by just saying that the result of the district court not having subject matter jurisdiction is clear from the case law. In Kingsley, if the district court doesn't have subject matter jurisdiction, appellate court does not acquire jurisdiction. And then the result of that, of course, is the proper procedure is to vacate the judgment entered by the district court and to dismiss the appeal, which I think is what we feel is the correct result here. I didn't get to the affirmative defenses argument. That's not a function of us not thinking that that's an important issue. It's merely a function of timing constraints this morning. To the extent that I have any time left, I'd like to reserve that for rebuttal.
I'll give you your full 5 minutes. This is a big, complicated case. So, and I'll extend some additional time to Mr. Lee if he so chooses.
Thank you, Your Honor.
With reason. So with that, Mr. Lee, it's your opportunity.
Thank you, Your Honors. May it please the court. Let me address the issues raised by Mr. Burris in turn. The issue of the motion to strike the testimony of Dr. Roberts, there are procedural issues that affect that, as well as Daubert issues. As the court animated in its questions to Mr. Burris, this was nothing but a motion in limine that was filed to exclude the testimony of Dr. Roberts. It was denied by the district court and not renewed at trial. We've cited a number of cases of which the court would be well aware that if you don't in Kansas, as distinguished from the federal rules.
So I don't recall from looking at the record. Was there a Daubert hearing in this case?
There was not an independent Daubert hearing other than the motion to strike. So how one characterizes that, Judge Warner, is probably debatable. But what is clear is that the motion to preclude this testimony made pretrial was not the subject of contemporaneous objection at trial, and so we've cited in our brief various cases, State versus Rodriguez Mendez, for example, which is a fairly recent 2017 case. As recently as Friday, this court affirmed that principle in Perez versus Wesley Medical Center to the same effect. And so we think that it is dispositive that there was not a renewal of the objection. Beyond that, the argument as to Dr. Roberts, as to the merits, really misapprehends, in our view, the Daubert framework. The focus, as the court is aware, is on qualifications. That is, as you would have seen from the record, conceded by the cooperative. The statement that Mr. Burris made at trial was, nobody's going to debate Dr. Roberts' qualifications. We, of course, agree with that. He's a preeminent expert in his field. But then the second part of that is the testimony reliable and relevant? There's not really a challenge as one reviews the briefing by the cooperative about methodology. They effectively challenge the conclusions. That's a subject for cross-examination. It's not a subject for exclusion under the rules in Daubert. And honestly, it would be difficult for the cooperative to challenge methodology because they didn't offer any expert testimony. There was not an expert that testified at trial for PCCA. So that is, we think, an insuperable obstacle for the arguments that it's making here. State versus Lyman.
Counsel, before you
Sure.
you go on,
Certainly.
I had asked Mr. Burris, and I'll ask you: was the jury instructed on damages, on how to formulate damages?
The jury was instructed on damages and the instruction was lost profits was the metric. That was what we submitted as a jury instruction, but more importantly, that is what the cooperative submitted as a jury instruction as the measure. They were instructed on that basis, and there was no objection by the cooperative to that.
So it's not preserved, and it's not an issue in this appeal. Our assumption should be, well, I mean, nobody's raised that issue, so our assumption should be that the jury was properly instructed.
That would be the correct assumption, we believe, Judge Brunson. As to the Daubert issue, we've cited State versus Lyman, a fairly new Kansas Supreme Court case, which quotes Daubert, where it says the focus must be solely on principles and methodology, not the conclusions they generate. That's exactly what we have in our view here from the cooperative's perspective. And given the complexities and that attend grain trading. If the court, which I know you have, has reviewed the testimony of Dr. Roberts, it's complicated stuff. I think he did a good job of making that digestible for the jury, but it's was clearly relevant and helpful to the jury. So we think between the fact that there was effectively a waiver of this issue by not objecting at trial, and the fact that the court went through a process of considering expertise and methodology, then that is an issue that I think we would suggest the court can give relatively short shrift. The fraud claim, in the sense of whether it's time barred, I mean, the point of departure, I think, as is always the case with this court or with any appellate court, this is a fact question. The court actually made the determination about the statute of limitations because this was not ultimately submitted by the cooperative for the jury's consideration. So the court under 6249.
Say that question. Say that statement again. You're saying the co-op didn't ask the jury to determine when the fact question?
The statute of limitations issue, Judge Schroeder, was not submitted to the jury. It was a determination made under 6249 by the trial court. And was not, the jury was not asked to consider that issue. So it's a fact question one way or the other. That's what 6249 is, as the court would be aware. If it's not submitted, if that question is not submitted to the jury, then the trial judge can make that determination. And if he or she does not do that, then it is assumed that it's consistent with what the jury has concluded. So in this case, the fact question was decided, and it wasn't something that the jury ever had an opportunity to consider, and that is because it wasn't urged by the cooperative. As to the merits of this issue, again, it's a fact question. When was it discovered? The records that allowed MKAC, our client, to discover the fraud were in the exclusive possession of the cooperative and were produced at a deposition during discovery. Obviously, that was within 2 years of the time the lawsuit was filed. It was also argued, and the court found that the breach of contract action based on a written agreement was within 5 years, and that written agreement was related, and Judge Schroeder, you focused on this a few moments ago, as to the moisture content. The contract, the lease agreement between the parties required the co-op to keep accurate grain ledger records. Moisture records are part of that. That was admitted by the cooperative at trial. And so either under the 2-year statute, because of when it was discovered, or the 5-year statute, that was concluded within the statute of limitations by the trial court.
Counsel, there's a principle in Kansas case law that says that when we're looking at discovery purposes for statute of limitations, that it's not necessarily when someone discovered the extent of the injury, but when someone discovered the injury, right? And so I understand what you're saying is it wasn't until a deposition testimony when your client discovered the extent of the injury from the fraud. But was your client on notice of the injury itself earlier than that?
No, Your Honor, and I appreciate your question. Our client was not, because the injury itself was this moisture level. In other words, when they were first apprised of the claim by the cooperative that there was, in the parlance that they used, that there was shrinkage involved, they actually thought there was a theft of grain, and so they went through processes to try and see if the putative thief could be located or discerned. They finally determined that wasn't the case, and what they said to the this is what the testimony of the CEO of MKAC says. We thought that this seems odd to us, but we don't have any evidence that says we don't owe this, and so they paid it in January of 2014. But they said at the same time to management at the Cooperative, if you would investigate this so that we can determine if there is an issue, that's what we would like you to do. It wasn't until the deposition that Your Honor referred to that it was revealed that, in fact, what the problem was. There wasn't theft. There wasn't a problem that MKAC created. It was the fact that the moisture level was not measured going in by the Cooperative, and thus it was impossible to know if there was a shortage coming out. There was only one side of the equation, in other words. So that was when the problem was actually discovered. It wasn't there were, and we cite to cases that say, in terms of discovery, suspicion is not enough, that there has to be actual knowledge. You couldn't say that there weren't suspicions, and in fact, that was testified to by Mr. Roenbaugh, who is the CEO, but he also said we didn't have any evidence of this until this occurred.
One question, was there, at the time of that deposition, was there already a fraud claim pending?
There was. Well, there was a claim that was characterized, and I'm only equivocating here because of the precise language that was used. There was a claim that suggested that that this was a payment that should not have been made, and that it ought to be refunded. That's more accurately how it's described. And obviously, fact questions are fact questions, and parties can disagree about those. But we do think that the discovery issue is clearly a fact question, and there is also the 5-year statute that really is not particularly at issue, because the court on 2 different occasions said, okay, the demand essentially was made in December of 2013, and the offset payment was made in January of 2014. This lawsuit was filed in July of 2018, so either one of those dates falls within 5 years of that time. So there are 2 different discrete but related fact questions, I think, that are involved.
So, counsel, before you move on,
sure.
So your position is it's a fact question. What significance is there that fact question was not presented to the jury? Who resolved that fact question?
The trial court, and that is something, Your Honor, that is contemplated by KSA 6249, because it essentially has a sort of a 3-part process where it says this is something that can be submitted to a jury, but if it's not, for whatever reason, then a trial court can make that determination. And if the trial court, if neither one of those things occur, then the assumption is that the jury's conclusion is consistent with the position that was advanced by the plaintiff in the case. So,
just so it's clear, neither side requested this issue be presented to the jury. Is that accurate?
That would be accurate.
Once the
yes.
case is submitted to the jury. I mean, did
Right,
anyone
yes.
request that be a interrogatory that's given to the jury on a special verdict form?
No, Your Honor.
Okay.
The third issue that was addressed by Mr. Burris is the question of venue and subject matter jurisdiction. I would sort of go backwards with this in the sense that Judge Bruns, you asked the question about whether it was waived or could be waived, and to the extent that it's waivable, it clearly was, because there was a counterclaim filed before the objection of venue was interposed. Court after court after court says you can't do that. You can't plead responsibly before you object to venue. And so to the extent that this is a waivable issue, then it was clearly waived at that point. But as to the issue more specifically of KSA 60-601, that is the argument that the cooperative makes is entirely premised on there being a claim for ejectment in the legal sense made. Venue is determinable at the time of the case comes to issue, when the petition is filed and the answer is filed. The court can look at both the petition and the answer. There is nothing in there that would suggest that this is a claim in the legal sense for ejectment, or that it has any potential to affect title to the real estate. Importantly, there is an allegation, as you might expect, in the petition that MKAC is the owner of the Dundee facility. That allegation is admitted by the cooperative in paragraph 3 of its answer. So from the beginning, there was not an issue as to title. We've shown there was MKAC disclaimed any claim for ejectment in relation to this motion to transfer venue that was referenced earlier. The pretrial order doesn't include that sort of issue. And the jury never heard about it, in instructions, and never heard about it in argument to the jury. So we think that is.
I have a question about this determination by the district court that the primary claim in this case is really one for a breach of contract and not for ejectment. If we were reviewing that, what is that? Is that a question of law? Is it a mixed question of law and fact? I'm just trying to figure out, because that will color our standard of review.
The standard of review, Judge Warner, is here, and I'll explain why, is abuse of discretion. And that is because the question for this court to determine is not really a legal issue. It is a factual issue as to whether MKAC presented a claim for ejectment. And we've cited a couple of cases in support of that idea, that if what the court is being asked to do is not interpret the statute, but interpret how the statute applies to a factual situation, then that is an abuse of discretion standard. And the cases we cite are in re marriage of Tevis Bleich and in re marriage of Reinhardt. One is a 2007 case, which I was going to say relatively recent, which would show my age, I suppose, but and then a 1997 case. So that's the standard. And I do think, I completely agree, Your Honor, that is an important consideration about what the standard of review is. But I think it's pretty clear that unless it's demonstrated that there was a claim for ejectment brought here, which we believe to be not likely, then it is an abuse of discretion consideration. And I realize, Judge Schroeder, I'm running long here, so I don't know how you'd like to.
I'll give you a couple more. I'll give you a couple more minutes. I gave the same courtesy to Mr. Burris.
Okay, well, thank you. I will just move fairly quickly to our cross appeal in this case. That is a product of the jury's determination that there was a breach of contract by MKAC by, in the verbiage used, attempting to prematurely terminate the lease. What happened that prompted the cross appeal was that there was testimony by the chief financial officer of the cooperative that the co-op was damaged in a fairly significant amount by virtue of having to put grain elsewhere because it was, per the cooperative's version, that this was the fault of MKC. That was, without belaboring it, that was a fairly hotly contested factual issue at trial about why that was. But what the two things happened that we think are procedurally monumentally significant, and one is that the chief financial officer testified about a document that he prepared that reflected the damages. And on cross-examination, I asked him, is there a document? Did you produce it to us? And also, why was the document prepared? And his testimony was, I prepared the document so I would have the information. And that is effectively a quote from his testimony. So it is pretty clear, we believe, certainly clear to us, that the CFO was testifying about the contents of a document contrary to the best evidence rule at 6467, and that's the only evidence that supports the counterclaim damage, the damage claim that in the counterclaim, and thus it cannot be characterized as harmless error. The admission of that testimony when you're testifying about a document and you don't produce the document, it should have been, there was a contemporaneous objection to that on the basis of best evidence rule.
So Mr. Lee, wait a second. Well, go ahead. I'll let the presiding judge go first. He probably is going to ask the same question I want to ask.
Well, my question is you knew from the pretrial order that the co-op had a claim for damages?
Correct.
Right. So was there a motion to compel any evidence to support that claim prior to, or to supplement any prior discovery, but prior to the trial?
Well, that's a excellent segue, Judge Schroeder. We filed. There was a lot of discovery in this case, as the court might suspect. One of the things that we asked for as part of a request for production were financial statements by the co-op. They refused to produce those on the grounds of relevancy. We deliberately did not pursue a motion to compel discovery in relation to those on the assumption that they can't support a damages claim without producing the financial statements that we requested. That is the second part of our cross appeal, which says that there was a supplementation obligation under KSA 60-226 when they discovered that they were going to assert this sort of a counterclaim that would have been supported by the financial statements. The objection that the cooperative made when we asked for these things was based on relevancy. In other words, they said there is no potential relevance to these financial statements. So it is certainly correct, Your Honor, that we knew that there was a claim for damages, but how that was going to be supported without production of the financial statements was the question that was that drove our strategy in relation to the case. And connected to that is this idea of having oral testimony only to support the counterclaim. When the chief financial officer says, I prepared a document so that I would have the information, that is clearly an admission that he is testifying about the contents of the document. So we objected to that. We objected to the instruction to the jury based on this, and that was on two bases. One was the best evidence objection, and the other was the failure to supplement objection. Under 6237, it's not necessary to file a motion to compel in order to for those sanctions to apply if the issue that is involved is the failure to supplement. And we have briefed that with
Okay. All right. So my other question is at the time of trial, I understand, my recollection of the record is the judge denied your objection based on foundation issues, not the best evidence rule.
Your Honor, there is past that, as you may recall, and this is unfortunately an issue, as the court is aware. This was something where there was not a court reporter involved. It was an electronic recording, and there was a sidebar with court where that was discussed, and then there is my statement to the court that is recorded that I would note an objection to this testimony. So that is that's the history. But your memory about the comment by Judge Gatterman about foundation is correct.
Regardless, as far as our standard of review, either way, it would be an evidentiary ruling and it would be an abuse of discretion standard. Is that correct?
Your Honor, the issue as to either one of those, we would believe would be an abuse of discretion standard. Yes.
Okay.
Are you
Well, having consumed no doubt my hour of argument, then if there are questions from the court, I would be happy to respond. So,
any questions? All right. Yeah, we've far exceeded on both sides our initial arguments, but Mr. Burris, I'll give you your 5 minutes in response.
Thank you, Your Honor. Just real briefly, some rebuttal to the cross appeal. Frankly, we think that the best evidence rule doesn't apply in this instance. Mr. Barnes, on direct examination, was not asked to testify about the contents of a document. Mr. Barnes has been the CFO of the co-op for a couple of decades now, and so any knowledge that he had of the co-op's damages as a result of Mid-Kansas's actions was independent of any kind of financial statement. And what this really boils down to is a discovery dispute that, from our perspective, was resolved prior to trial even occurring. The discovery request that Mid-Kansas sent to the co-op requested financial statements, it requested documents having essentially any relation to financial statements. And so we appropriately objected to that request based on relevance and being overly broad, since it could potentially encompass a whole universe of documents. And so that was the basis for our objection. And in response, Mid-Kansas filed no motion to compel. And so our position in that regard is failure to file a motion to compel on this issue means that this issue is not preserved for this appeal. And so that's our position on that. Judge Warner, I think that you asked some questions about venue and what's the standard of review on venue. And as we
actually, my question was a little bit different from that, counsel. My question was the determination by the district court that this is primarily a breach of contract action, not an ejectment case. What is our standard of review for that determination?
Okay. I think I misunderstood your question. I apologize. We have set forth numerous examples of Mid-Kansas over the course of this case, seeking ejectment and making it quite clear that ejectment and immediate possession, which is a remedy for an ejectment action, is something that it was seeking through this lawsuit. As far as venue goes, we cite the standard of review in our briefing. Venue is a matter of jurisdiction, and a challenge to a district court's subject matter jurisdiction raises a question of law, and as a result, the appellate court's standard of review is unlimited. And so that's our position in that regard. Just kind of wrapping up here, the Mid-Kansas raises, kind of getting back to the cross appeal issues, that it was unfairly surprised by Mr. Barnes's testimony, and that testimony should not have been admitted pursuant to KSA 445. Surprise is determined by whether the opposing party had prior notice of what was coming at trial, and there was simply no surprise here. The co-op's counterclaim damages were clearly identified in the pretrial order. Pretrial order also set out clearly that those damages resulted from the decrease in grain volume caused by Mid-Kansas's premature termination of the lease agreement. In addition, the co-op actually did produce a very large volume of documentation that contained the volume information, grain volume information that Mid-Kansas claims that it never received. And that Mid-Kansas chose to do little, if any discovery at all, into the decrease in volume laid out in those documents is frankly its own fault, and it's not the co-op's. So those are my closing comments. If any of your honors have any follow-up questions, I would be happy to address those.
I don't.
You don't either.
All right. Mr.
Thank
Lee?
you.
Your Honor, I really don't have any other comments for the court. And I think probably we've spent enough time on this, so I appreciate the opportunity, but I probably don't need to make any additional comments.
Well, thank you, counsel. It's an extremely interesting case. We'll take the matter under advisement and issue an opinion as quickly as time allows. Thank you both for your involvement.
Thank you,
Thank
Your Honor.
Thank you.